Previously, we were able to challenge discrimination and challenge discriminatory laws, which have remained on the books, by the way, even though they were declared unconstitutional in the courts. Going forward, unless we expand the court to balance it, we will have no hope of having our rights recognized by the current court.
Welcome to the East Anchorage Book Club podcast. I'm your host, Andrew Gray. Today on the show, we follow up from last week's episode about marriage equality in Alaska. Several times during that interview with Matt Hamby and Chris Sheldon, plaintiffs in Hamby versus Parnell, which brought marriage equality to Alaska in 2014, we mentioned that we really needed a lawyer. Today, we have one of the lawyers from their case, Alaska-born and raised civil rights attorney Caitlin Shortell. This is a denser podcast episode for sure, but I promise if you stick with it through some of the more technical aspects, we get to some important points that you need to hear. Caitlin Shortell, welcome to the podcast.
Hi, thanks for having me.
So I guess to get started, how did you first get involved in the case that came to be known as Hamby versus Parnell?
So I was born and raised in Alaska, and I am a private lawyer. I was at the time in private practice, and I still am. I had been out of law school for about 14 years and practicing in Alaska when there was a wave of lawsuits in different states that were emerging to challenge same-sex marriage bans throughout the United States. And myself and my former law partner, Heather Gardner, decided we should file a lawsuit. And so at the time, both of us were out of state, in part because we were really tired of living in a state that discriminated against LGBT people. And we were in Seattle, both of us at the time, and we decided we were going to file this lawsuit. I was coming back and forth to Anchorage and still practicing law in Anchorage. And I contacted the ACLU of Alaska to ask them if they would be interested in partnering. And they responded and said that they didn't think it was a worthwhile use of their resources at the time because there was a case within our region, the court, what's called the Ninth Circuit Court of Appeals, that on this topic. Of course, that case was not about Alaska's constitutional amendment and statutes specifically. And also there were Alaskan individuals who were either married in other states or wanted to be married in Alaska and were barred from marriage, its recognition, and the benefits by the same-sex marriage ban, constitutional amendment, and statutes. And so we determined that we would file a lawsuit. And then after we announced that, we did get some interest from another lawyer, Allison Mendel, who became a third attorney on the team. And she was in a different law firm. And also ACLU of Alaska filed an amicus brief, which is a brief asking the court to let us prevail. And so we put a word out on social media that we were going to be doing this. And there were 5 couples who ended up becoming plaintiffs in our lawsuit. And Matt Hamby and Chris Sheldon were one of the couples. The case is called Hamby because Hamby was the lead plaintiff, but there wasn't any specific significance to that because there were several other couples who had an equal interest in being plaintiffs and challenging our discriminatory laws.
I want to do a little history lesson for our listeners. Can you talk a little bit about 1998 and the constitutional amendment to only recognize a marriage between a man and a woman? Were you living up here then, and do you remember that time?
So I was in law school at the time. So I was living I guess I was probably between Boston, where I was in law school, and San Francisco, where I did a lot of co-ops. I went to a school that incorporated full-time internships in the last 2 years of law school. So I was not living here at the time, but I did clerk at, so I had, at previous times in history, when LGBT rights were put on the ballot, my dad actually, who was a Superior Court judge, was a judge who ruled on allowing a different ballot initiative to go on the ballot. And then I clerked for a judge, Judge Joanides, who also ruled on LGBT rights, but I wasn't involved in that at the time because I left. So I wasn't here, I wasn't present, and that wasn't something that I experienced firsthand, but we did review the record to glean the discriminatory intent in the legislature, in the legislative record when we filed Hamby.
This is just a piece of trivia. I lived here in 1998. I was having a great time and I was not tracking politics, and I don't recall anything to do with that constitutional amendment happening. And I was very much a 23-year-old gay man going out to the bars and hanging out with my friends. And it just wasn't on my radar, which is a little bit embarrassing for me now, looking back, but it wasn't really part of it.
I think that brings up a really timely issue, which is that a constitutional amendment is kind of arcane, and a lot of politics really is. I mean, at the time that we filed Hamby, I'm bossy. So I made several of our plaintiffs promise me that they were going to register to vote and stay informed about what was going on in the legislature, because we always have a lot of frightening things happening in terms of LGBT rights, women's rights, and other issues that really concern all of us very much, concern our fundamental rights. But many of us are not at all informed about how the system works or, what's going on. And we know that right now there is a campaign to have a constitutional convention, and that would very much threaten our constitutional rights that we have in our state constitution. And it's going to be imperative that people not only vote for pro-equality candidates, but that they vote against a constitutional convention, because that's a bigger conversation, not specifically the same conversation as we're having now about Hamby, but we at the state level, with the current Supreme Court of the United States that we have being very extremist, we need to protect the rights that we have in our state constitution. And we don't want it to change right now, because there's a great fear that right-wing extremists would successfully eliminate our right to privacy specifically, which we have, that's a positive privacy right in the state constitution. But I guess we're getting a little off track from
we are. I want to talk about all of this stuff. I just kind of want to frame it. So getting back to Hamby versus Parnell, that case, this is where we kind of needed the lawyer when we were doing last week's interview, is that case was being argued. I guess, were you guys at the, was Burgess, was he at Superior Court or was he at Supreme Court? What stage were you guys?
There's so much to this for a layperson to learn. So maybe I can just tell you.
Yeah, go ahead and tell me.
The whole thing. Okay,
so, tell me the whole thing.
So Superior Court is one of the courts in state court. So we were not in state court. We were in federal court.
Okay.
And we were bringing the case under a federal statute that is called Section 1983. So that federal statute allows people to sue the government, even though it has sovereign immunity, by suing state actors who violate the constitutional rights of individuals. Okay.
So it started by suing Governor Parnell.
So there were a number of state actors that we
Okay.
sued, and they were the people in the state government who were responsible for enforcing the discriminatory laws that we alleged violated the constitutional rights of our clients. And Judge Burgess was the judge who heard this case. And he was a United States district court judge in the district for the District of Alaska. Alaska has one district. Other states like California, I did an externship with a judge in district court for the northern district of California, but here in Alaska we have one district, the District of Alaska. So we filed a lawsuit alleging violation of, it was a 1983 lawsuit, and we're saying these laws violate the constitutional rights of our clients, and we are suing the governor, the AG, and the commissioner, or excuse me, the director, the commissioner of vital statistics, because they issue marriage licenses. So there are other lawsuits that I've filed also under 1983 where I've named other state actors who are specifically responsible for doing whatever it is I'm claiming is violating the constitutional rights of the plaintiff or plaintiffs. So does that make sense?
You did a good job of explaining that this was a federal case and how it was being heard. And I guess to get to that point where, this was happening in 2014, Obergefell, which for our listeners was the case that legalized same-gender marriage nationally, was moving forward somewhere else and was going to go to the Supreme Court. Can you explain what happened with Obergefell and how that affected your case and how the judge rested? Or I'll get the words wrong.
Okay, so what happened was that we won our case on October 12th, 2014. We won our case, and when Judge Burgess in the District of Alaska, he heard an argument over a motion that the state defendants filed, and their intent was to get our case dismissed without a trial. And they argued that there was essentially all of these cases nationwide argued there's no constitutional right to gay marriage. There's no right to gay marriage in the United States Constitution. Therefore, there's no case here. And they argued a number of other things that weren't convincing. And we argued that we were presenting constitutional violations that these laws affected, and that that the court should grant us the relief that we asked for, and just as a matter of law, meaning you don't need to hear evidence on this. Everyone agrees that this is the law, and by the language in the law, it specifically discriminates against same-sex couples. And you can decide as a matter of law that these statutes and the constitutional amendment discriminate against the plaintiffs. And we were asking for declaratory judgment, a declaration that these laws violated the constitutional rights of the plaintiffs, our clients, and we were asking for a permanent injunction, meaning injunction means stop. It means you must stop enforcing these laws. And so the result was that the decision by Judge Burgess on October 12th, 2014 decided that, yes, these laws were discriminatory they violated the constitutional rights of the clients, and granted a permanent injunction saying from this point on, you may not, state actor defendants, you may not continue to enforce Alaska's constitutional amendment and statutes saying that marriage is between a man and a woman, saying that same-sex marriage to perform it is a misdemeanor, saying that there shall be no recognition of same-sex marriages that are from other jurisdictions, saying that you can't issue marriage licenses to same-sex couples, saying that you can't get benefits because attendant on marriage because Alaska doesn't recognize same-sex marriage. So the court said, stop, you must stop enforcing that. You're not allowed to enforce that permanently. And then following that, the state defendants, so they were represented by the AG's office, they asked the court to stay, like put on hold that order, and the court denied it, and then it went up, so the federal court system goes up from the district court to the Circuit Court of Appeals to the US Supreme Court, and their effort to stop our victory was unsuccessful. So they had to start issuing marriage licenses just a few days after we won the case. And they were also at that point ordered to stop enforcement of the laws. But the thing that we didn't know until 5 years later was that under the direction of the state, the Department of Law, this advised at least one agency to continue to enforce the discriminatory laws that they were ordered to stop enforcing, not only until Obergefell was decided in the following year, but for 5 years. So shocking. Truly shocking.
So I think the issue at hand, I think the concern, the thing that's kind of changed everything in the last couple of months is the leaking of the Supreme Court opinion drafted by Judge Alito that would overturn Roe v. Wade. And what my layman's understanding is that Roe v. Wade guaranteed access to abortion based on this same portion of the 14th Amendment and with the right to privacy. And I mean, I'm going to tell you straight up, it's hard for me as a non-lawyer to really wrap my head around it. So rather than going more into the weeds with like what it means, I guess let's talk about what the consequences are. So Roe v. Wade falling, it seems, would undermine other Supreme Court decisions that used aspects of Roe v. Wade as precedents for making their decisions. Can you talk a little bit about that or set me straight?
Sure. So the idea that we have, the principle that we have of precedent is an idea that the courts, they make their decisions in part based on what that court or a higher court that controls say it's a lower court. Like, for instance, we were arguing before Judge Burgess in the district court that these laws violated due process and equal protection. And we said, Judge Burgess, you have to rule in our favor because, this is within the Ninth Circuit. It's already basically this decision that just came out is controlling on your decision. So there's like a hierarchy with the courts, right? So, and when the United States Supreme Court is at the top of the hierarchy. Okay, so the United States Supreme Court, when it's making decisions, it looks at its own precedents. Cases make their way up to the Supreme Court when there's a disagreement among the circuits throughout the country on a particular issue. And there's a federal question, for instance, like in our cases, in civil rights cases, about do these laws violate constitutional rights? So the really shocking thing I would just, because I'm a lawyer, I would be like, well, it didn't exactly start with when you said it started with this leak. And I'm thinking, no, it did not start with the leak, because they have been planning, the right wing has been planning to try to overturn the gains that we've made that are really, I mean, it goes all the way back to the 14th Amendment and wanting to overturn the 14th Amendment, wanting to overturn all the civil rights gains that we've made for women, for LGBT people, for people of color, for disabled people. So, and to, just change so they're now engaged in a process of trying to argue that many of the right wing jurists and conservative people, they tout what's called originalism. Originalism is supposed to be arguing that we should decide things based on the intent, the manifest intent of the founders, the framers in the Constitution. So the big argument that they make is, and that was made in the leaked draft, was there's no this must be overturned. Apologies for the road noise, because it's not a right that's found in the Constitution. The same argument was made about Obergefell, that this is, and then if you're really into this sort of thing, then you can read about a million people saying, what the hell are they talking about? Their account of what history is, or what was, whether it's like the history of abortion and its legality, or of any issue, it's all up for debate, right? So, but the right-wing jurists try to argue that we need to overturn precedents that they say are wrongly decided, even though their job is pretty much to leave precedents, especially super precedents, very important decisions that they've made, to leave those intact. But they are being what they so often try to have criticized the left for being, activist judges, and they are using this notion of originalism to try to undo civil rights gains. So things like LGBTQ rights, same-sex marriage, abortion, these are all things that, happened after, that were legalized after the Constitution was written. So basically, they're not just it's not just an unfounded fear. It's, now that we've seen the leak, and also lots of other federal court decisions and U.S. Supreme Court decisions that have been coming out. It's clear that their dream of overturning Roe and likely overturning LGBTQ marriage, and then going after contraception and interracial marriage, this is where they're going.
So a couple of things. Number one, when the Constitution was written, many of those men who were writing it owned slaves. So that seems problematic, that we certainly acknowledge that certain things that were happening, in the late 18th century are not things that are happening today for good reason. That times change and our expectations change, and what we say is okay and what's not changes. And that's good. The second thing is that I think some would argue that Clarence Thomas is the most conservative judge on the Supreme Court. And he is married. He is, an African-American man married to a white woman. So I would find it shocking if that court went after Loving versus Virginia, since it would have such a personal effect on him personally. So I feel like there's certain things that I think they're all in the same family, but I think certain things are going to get a pass and not be a part of that. I mean, that was just me offering.
Well, so I want to say something to that, because I personally know many people who work for anti-LGBT equality politicians who are gay,
mm-hmm.
who are women,
mm-hmm.
who will likely need to use contraception or have reproductive health care access. I know very eminent women politicians who are responsible for the Supreme Court that we currently have, that's going to overturn Roe versus Wade. So I don't know. I don't have a crystal ball, and I really don't understand the psyche of these people. But we know they exist. We know they are on the Supreme Court. We know they're in Congress, and we know them in our own community. There are lots of people who are betting that, oh, this won't affect me personally, or I don't know what the deal is, but they don't stand up for equality, even though it will personally impact them.
Hey there, folks. Spirit of Alaska here. Let's take a little time out. Let's refresh ourselves with a little guided meditation. Close your eyes. Take a deep breath. And I want you to think about someone who would enjoy the East Anchorage Book Club podcast. Imagine yourself recommending the podcast to them. And imagine their joy at discovering something new. Now let that breath out and slowly open your eyes. Now don't you feel more centered, more in tune with your own spirit? I'm glad I was able to help. And now, back to the interview.
If Obergefell v. Hodges were to fall, what would happen to people who are currently in same-sex marriages? I mean, what would our marriages cease to exist? Would we be divorced? Like, would it be like having a divorce? How does my home, the ownership of my home, which is with my husband, we bought it together, how does that work?
Doesn't it sound like a total insane mess?
Yes. It sounds like it would be absolute insanity.
Yeah, but I mean, think of other governments. Think of like what happened when Jews suddenly were not allowed to practice their professions, became property. They were declared to be stateless. Mm-hmm. Their property was multiple times in different countries, and everything we thought was like there are instances in fascism where the things that we take for granted. I mean, I think the bigger category, the bigger umbrella is, hey, wait a minute, I thought we lived in a nation of laws. But when the government doesn't respect our rights or enacts discriminatory laws, and then the court says it's okay, then the reality is that we're going to suffer discrimination. And so so here's like the specific scenario. If the United States Supreme Court, so this could play out in different ways. Like, for instance, one way it's played out is that we won Hamby and the state of Alaska started issuing marriage licenses to same-sex couples, many of whom are our friends and loved ones, or it's us, right? But then we didn't know it, but they kept enforcing the same-sex marriage ban laws, contrary to the court order that they had to stop, to deny military spouses and kids their PFDs stationed out of state with their spouse or parent. They denied them based on the same discriminatory laws, and told people in writing, our state does not recognize same-sex marriage, and the AG's office gave them legal advice to do that, and they repeatedly did it to many people over a period of years. So what just blew my mind when I discovered this, and then I had to go back to court and sue about it, was, oh wow, I thought we won that fucking case already. I can't believe we're here again. So it could either be like all you really have to have is bigoted state officials who are going to either enforce discriminatory laws, even when, like right now, when the law of the land is Obergefell for the whole United States, or the law of the land for Alaska from October 12th, 2014 was Hamby. You can't enforce those laws anymore, but they kept doing it. So if we have a governor, an AG, legislators who are bigots, who view, like before the Republican Party platform was Trump, it used to include a provision, which is like the year before, it used to include a provision saying marriage is between one man and one woman. So if we have elected officials and appointed officials who enforce discriminatory laws, even unlawfully, then we will suffer discrimination. We will not get benefits we should have. Our marriages, all the more than 1,000 benefits that we enjoy, we may not enjoy. But the big difference now that with the extremist Supreme Court that we have is previously we were able to challenge discrimination and challenge discriminatory laws, which have remained on the books, by the way, even though they were declared unconstitutional in the courts. Going forward, unless we expand the court to balance it, we will have no hope of having our rights recognized by the current court.
Part of the reason why we all celebrated so much in 2015 is that we felt this was a clear demarcation in time, that from this point forward, things will be different. It came up in the interview last week. Matt Hamby said, we were told that once you let the toothpaste out, you can't put it back in the tube. And it seems that we were wrong. Maybe they're going to try to put that toothpaste back in the tube. And I think that's just, it's almost too much for me to even wrap my head around. Like, I cannot even fathom that it's happening because I had so given up that weight of not having that.
Mm-hmm.
It's really crazy.
I mean, I feel like the person who's always like the harpy and the buzzkill, but I've been pretty aware of this entire time. I mean, I was super enraged when I found out about the PFD denial because I had never imagined that the state was doing what it was doing under Walker his entire term, and then
well, so and just I'm gonna just tell, we've kind of talked about this a few times, but we haven't really spelled it out. So what this was it meant that people who were stationed outside of Alaska but kept their primary residence in Alaska should have been able to apply for a their spouse should have been able to apply for a PFD using that primary residence as well. But the state of Alaska, sorry?
Their accompanying spouse and their dependents,
all right,
by law, are entitled to receive a PFD.
Because that's what a straight heterosexual couple with children would get if they were stationed anywhere else.
Yeah. But they were specifically being denied, and written notices were going out to them stating the basis was the Alaska same-sex marriage ban laws.
It seems really, really wrong on so many levels. Like, I don't even know how they thought they could get away with it, because it's a federal right to marry. Like, so it is very shocking. So thank you for your work on that case.
Yeah, you're welcome. I got targeted by the then AG, Kevin Clarkson, who later was forced to resign because he was sexually harassing a subordinate employee. And he used the Department of Law to issue an official press release accusing me of filing a false lawsuit, which then turned out to be completely the truth. And then hundreds of pages, like 1,000 pages of documents were produced in that lawsuit proving the truth of what my clients, and I represented 2 adults, and then one of them, her 2 children, who had all been denied. But then also we had a PFD employee who is a gay man who informed us that this was had been happening for years. And then it was borne out in the documents. And it was very surreal for me because sometimes it feels really lonely doing this kind of work, because like you said, you were a gay man who's married because of the work that many of us did. But when I was doing the lawsuit about PFD, almost no one in the community, including gay, lesbian people, were really supportive
I,
or
I,
cared.
I apologize to you.
That's
I mean, I'll
okay.
apologize. I mean, on behalf of all those people who didn't care, I think that for so many of us, when it's not about me, it's not about me, and people go about their everyday life, and the, military person who's in a same-sex marriage who gets stationed somewhere outside of that's just such a small number of people. I just think it just wasn't on our radar, and I'm sorry
It's
because
okay, but I
it's an
did also
insane
hear
thing.
from other people who said, yeah, that affected me too.
Mm.
I mean, other people in addition to the people I represented. So, and also, I mean, I'm continuing to because this is of such recent history
Mm.
that, for instance, I have a case right now involving a same-sex couple that are getting a divorce. And one big issue that's coming up a lot is, when should the court see what are the dates of the marriage? And the reason that matters is, so one question you had asked a few minutes ago is like, what would that mean? Would it be like divorce? So one of the issues about not having about the same-sex marriage ban laws is that if there's no marriage, there can be no divorce, right? So one of the benefits that
Mm.
we got was the ability to get a divorce, which is important, but attendant on divorce is what's called the equitable division of property and debt.
Mm-hmm.
And that's different from, uh, you can have a domestic partnership too, but it's much more advantageous to people to be considered married. So imagine, because when you're married, you're with some exceptions, you're acquiring property and wealth, and that is marital property. And then if you were actually married in, California in some much earlier year, and then you had acquired all this property, but then you get a divorce and you're only considered to be married from July 1, 2015, or whatever date after that you got a marriage in Alaska, that was like July 1, 2015 is when the state said, okay, we're dropping our appeal because
Mm-hmm.
Obergefell was decided. So that means like you are really losing out on a potentially a massive amount of property that you should have the right to have the court divide equitably as marital property. And you would have to do things like, number one, argue that a domestic partnership was formed. Number two, then argue about every single asset. What was the party's intent with regard to every single asset? So I have a case that's like this right now, and also includes a prenup. So it's very complicated. And I mean, here I am. I'm in state court, but I'm making a federal case about it, laying out the entire history of the marriage cases in Alaska and nationwide, to try to argue, like, some courts have held that the remedy for the discrimination that we faced is to recognize the marriages that are pre-Obergefell. For
Mm-hmm.
the, like, Colorado did this recently,
So
for common law marriages, which we don't have here. But anyway, basically, like, the struggle continues to get recognition, even now, for all these marriages that were before that arbitrary date that the state just gave up on its losing battle to defend its.
Caitlin Shortell, thank you so much for all your work and for explaining so much of this information today. I mean, it can get really dense. And so we sincerely appreciate not only your hard work on the case itself, but coming on the show today to talk about this stuff. Can you recommend a book to our listeners?
Yes, and I actually brought it with me. It's called Allow Me to Retort, A Black Guy's Guide to the Constitution by Elie Mystal. And that's Ellie. And he is amazing. And I believe he's coming to speak at the Alaska Bar Convention, which is like the biggest celebrity spotting that I'll probably ever have in my life. I saw RBG and Sotomayor speak here. And those were both really, it was an honor to be able to see them. But in a way, to see Elie Mystal will be like even more amazing to me. And so he is a legal commentator, and he is very blunt about just the problems with our Constitution for all of us, women, people of color, LGBT people, just the white supremacist roots of our whole system. One thing that he says a lot of the time that I just want to cite is he says that the courts have, of the three branches of government, only one, the courts have veto power over the other two branches. So that really explains why the courts are so important and why we're in so much trouble with a really extremist Supreme Court. Because, here's an example. People are saying, Democrats are saying, we need to codify Roe, and have tried to codify Roe to make sure we protect our rights. But the problem with that is it's predicted that this Supreme Court would simply strike down any law codifying Roe because they have veto power, essentially. So, but I love Elie Mystal. I highly recommend everyone read his book, listen to it on Audible so you can hear him yell, watch him on TV, follow him on Twitter, and worship him because he's amazing.
Thank you so much for that recommendation, and thanks again for being on the show today.
You're welcome.
Thank you to Corey Coolidge for making this podcast episode listenable. And thank you to you, our listeners. If you like what you heard, please subscribe, rate, and review us. Next week, the plaintiff in the federal marriage equality case, Jim Obergefell.